All right. Well, good afternoon and welcome to the second of the Office for the Advancement of Research's spring semester book talks. I am Dan Stageman, Director of Research Operations, and this afternoon we'd like to welcome one of our own faculty members, Evan Mandery, who will be presenting on his book, his 2013, correct? 2013 book, A Wild Justice, The Death and Resurrection of Capital Punishment in America. Evan, as most of you know, is Professor and Chairperson of the Criminal Justice Department here at John Jay. He is a graduate of Harvard and Harvard Law School. Evan brings his experience as a former capital litigator and the author of 15 or more, I imagine at this point, law reviews and a textbook, currently in its second edition, on the subject of capital punishment to the writing of A Wild Justice. He is also an active fiction writer and has published 3 novels, including most recently Q, which was published in 2011 by Harper Collins. Evan today will be presenting on his book, A Wild Justice, which draws upon never-before-published original source detail to tell the epic story of 2 of the most consequential and largely forgotten moments in Supreme Court history: the striking down of Georgia's death penalty law in Furman v. Georgia, 1972, and its swift reinstatement 4 years later in Gregg v. Georgia. In the process, it gives an extraordinary behind-the-scenes look at the court, the justices, and the political complexities of one of the most racially charged and morally vexing issues of our time. Let's welcome Evan.
Thank you very much. That's the first time I've ever received applause at John Jay. I expect it will be the last. Welcome to you all, Mom, Dad. Very nice, happy to be here today to be able to chat a little bit about my book. I taught here a long time, so I will make the presumption, which I think is pretty safe, that none of you have read it. I'd definitely much rather have a conversation about the things that are on your mind. I know the story. I know what I think about all of the issues. So I'll try to say enough to spark the conversation, and we can take it from wherever you like, to wherever you like. I'll tell you the end of this story first. Since 1976, or 72, depending on how you count, we've lived in the United States with 2 foundational principles of death penalty jurisprudence. The first is that a non-arbitrary death penalty is constitutional. In other words, the death penalty isn't inherently unconstitutional. And principle number 2 is that that requirement of non-arbitrariness is satisfied by a system in which a state creates aggravating factors, a system of aggravating factors that make certain crimes worse than the other, and bifurcated trials. And what's remarkable about those 2 principles is that principle number 1 was arrived at by 2 Supreme Court justices, one of whom opposed capital punishment, and principle number 2 was arrived at by 3 Supreme Court justices, one of them the same, 2 different, all of whom opposed capital punishment. And in this entire history of the constitutionality of capital punishment, which almost everyone understood to be largely about race, there is basically no explicit mention of race. So how can it be that we live with these 2 arguably contradictory principles of capital punishment that weren't even supported by the people who implemented them, and with a narrative that has almost nothing to do with the reality of how the cases were decided and understood by the actors? So you could read the 600 pages, or I'll take you through the story in brief form. It's definitely less an argument about the pros and cons of the death penalty. I have my views, I'll share them, but I'm much more interested in storytelling about law. And as a teacher, I have some students here, if they haven't actually taken a law class with me, but one of my strongest feelings is that law is a very disempowering language, that people don't feel that they have the right, the intellectual capacity to make arguments about mixed questions of ethics and law. There are folks in the back. There are 10 seats up front if you want to. I'd prefer it if you were comfortable, so you could do it selfishly for me. Sorry, I was such an adamant backbencher in my life as a student that I also would not have come. I would have chosen to stand in the back even if the entire set of seats was open. So I'm very interested in, if any of you have gone to law school or you've read about law school, you know the law school experience is shaped almost exclusively by reading the text of decisions. And those texts, I think we can say through historical research, are often or always proxies for what the justices or judges who are deciding those cases believe. And in my history, such grossly imperfect proxies for what they believe that they have almost no connection. So I think that focus is misguided, and I definitely think at least part of my project was to maybe think a little bit more broadly about how we educate lawyers and talk about the law. So I'll put that on the issue of table of issues that interest me to speak about with you. But the story itself begins, my book opens in 1963, and at the time it's axiomatic that the death penalty is unconstitutional. Whatever your views on the death penalty, I know where we are, so I can make a pretty good guess about how this room would poll if we asked the question. But in 1963, everybody, regardless of your view, would regard the position as debatable, right? Whether the death penalty is constitutional or not, and whether it's cruel and unusual punishment. In 1963, no one took that position. There was exactly one law review article which had been written in 1962. I'm actually supposed to speak to this man's daughter. I never connected with him. I wasn't aware of her when writing the book. He was an entertainment lawyer based in Los Angeles, and he outlined an argument in the UCLA Law Review that the death penalty was unconstitutional. He was literally the only person in quasi-academia who would ever advance that position. And the reason is simple. Capital punishment is mentioned 5 times explicitly or implicitly in the Constitution. And the prevailing jurisprudential paradigms at the time would have either said that we had to adhere to the text of the Constitution, in which case it's constitutional, or that judges should be restrained from deciding matters that are best left to the legislature. And that also would have led to the conclusion that the death penalty was constitutional. So in 1963, this changed, and the transformative figure in this debate is largely forgotten to history, probably not to Jerry, maybe not to other people, but Arthur Goldberg was a Supreme Court justice who served only 3 years on the Supreme Court, but I make the case in the book that he fomented an intellectual revolution in how people thought about the law. And Goldberg's position was that the Constitution should be treated as an evolving document. And in the long version of this conversation, I talk a little bit about, I explore in the book, how it was that Goldberg came to this conclusion, why no one else had reached it before. There's definitely an appropriate subtitle for my chapter would have been Go Jews. There's definitely a very strong, there's definitely Goldberg's history with the Holocaust and some personal experience he had had with Leopold and Loeb, and actually some religious textual interpretive issues led him to reach this conclusion. And he was abetted by his ally, Alan Dershowitz, who was a 24-year-old law clerk at the time. Goldberg inherited Felix Frankfurter's seat. It was known on the court as the Jewish seat. That's not a joke. I wish it were, but it's not. During Goldberg's first term, which was the remainder, he had Frankfurter's carryover clerks from the previous term, none of whom he thought were well-suited to take on this heretical project that he wanted to. But he thought Dershowitz was the perfect man for the job. Dershowitz had clerked a year earlier for a man named David Bazelon, also largely forgotten to history, but a titanic figure in the legal community and extremely influential on a host of very influential people, including many Supreme Court justices. And Goldberg decided that he wanted to take on the death penalty. And what he did, he engaged in multiple heresies. And the core of his heresy was procedural. So the problem was, because nobody perceived that the death penalty was unconstitutional, and nobody thought that the court would even be receptive to the argument, lawyers didn't raise that argument on behalf of their clients. So you didn't have the issue percolating in courts of appeals or in the Supreme Court so that they could just say, okay, let's grant certiorari on this question and decide it. So what Goldberg undertook to do was to raise the issue on behalf of some of these clients that the death penalty was unconstitutional and have the court decide it on its own. There's no analog, there was no prior example of this in Supreme Court history, and actually, to my knowledge, none since. And he had Dershowitz spend the summer of 1963 researching arguments against capital punishment. And Dershowitz's research focused largely on the use of the death penalty and racial patterns in the South. And what he found was extreme. The death penalty was used often for rape during the 1960s. And he found in the southern states that he studied not a single example of the death penalty being used against a white defendant, and obviously many, many examples of it being used against African Americans. So Dershowitz's initial memorandum, which Goldberg then circulated to the court, was focused by and large on race. There was it sparked controversy, to say the least. And it's interesting, if you are a student of history, one of the peculiarities of this is that Earl Warren, who is known to all of us as a great liberal reformer and advocate, actually vigorously advocated against Goldberg publishing this memorandum as he wanted to do, and against the court acting on this. And Warren, and I'll say this, whatever the substantive merits of his position, Warren was formerly the governor of California, and his political instincts, I think, are entirely vindicated by history. He thought that the public wouldn't tolerate the Supreme Court intruding on this matter, which A, was the province of legislators, and B, would be interpreted by people as being the court coming down as protective of black murderers. And so Warren discouraged Goldberg. Goldberg had tremendous respect for Warren, and he backed off. They reached a compromise. Goldberg published a dissent from the denial of certiorari, and he published a modified version of the memorandum. To Alan Dershowitz's great dismay, the dissent, which is just a lawyer would appreciate this. Suffice it to say, the publication of a dissent from certiorari is a very, very rare event and very odd. But it didn't mention any of Dershowitz's research on race, and Warren specifically asked Goldberg to take it out. But Dershowitz, I got to interview tons of people I never would have otherwise met in my life. It was, aside from getting married and having kids, one of the best experiences of my life. I'm friends to this day with a man from the NAACP Legal Defense Fund who I regard as an American hero. I was lucky I got him an honorary degree at John Jay. I get emotional thinking about him. He was sick for a while. And I got to speak to Dershowitz, and Dershowitz, and he was very, very upset when this happened. But the consolation was Goldberg said this would be an ongoing project, and Dershowitz, at Goldberg's urging, published his memorandum. He published his research, not just the modified version that the court put out, that went out in this form of this dissent, but the longer version that contained the research on race. And this was a klaxon to the NAACP Legal Defense Fund, the same lawyers that litigated Brown versus Board of Education, Thurgood Marshall's, the entity that Thurgood Marshall created. And they understood the publication of Goldberg's dissent and receiving Dershowitz's research to be a signal, not a very subtle signal, that there were at least 3 people on the court who were seriously concerned about the constitutionality of capital punishment. Goldberg, by the way, was joined by William Brennan, who was real admirably consistent throughout this history. As I talk a little bit more, some of these people that you may recognize as liberals were not liberals at the beginning of their career, but Brennan had a perfectly consistent position from his first day on the court. And William O. Douglas, who's a very strong liberal voice, but as will become evident in a few minutes, a very difficult, to say the least, person, and the difficulties of his personality bollocksed up some of this history in ways with unforeseeable consequences, I think. So the NAACP Legal Defense Fund took up the cause. And one direct consequence of this, in addition to the man I mentioned, whose name is Michael Meltzner, who kind of took the lead from the NAACP's end in litigating these cases, it brought a man named Tony Amsterdam to the cases. And Amsterdam, if you're not a lawyer, you won't really be aware of this, but he, I would argue, is the most influential lawyer of the 20th century. He's alive today, still extremely influential, but he argued every major death penalty case and a host of other seminal civil rights decisions. I had the chance to interview him too. Everybody in this universe, you can't hear this spiel about this history without at least hearing one thing about him. He outworked everybody by an order of magnitude. And Meltzner, the man who I keep mentioning is my friend, is a genius. He's a Yale Law School grad, Oberlin undergrad. He's founded clinical legal education at Harvard, became dean of Northeastern Law School. He's a titan. He says, I'm nothing compared to Tony. Amsterdam was one of these guys today. I've had this experience where if you email him, you get a 7-page email, single-spaced back at 3 o'clock in the morning. There are tons of fish stories. This one seems apocryphal, but it's been repeated so many times, he gets the benefit of it, I think, where he's arguing a case in court. He cites a case to the judge. The judge says, you've miscited the case. Amsterdam says indignantly, Your Honor, your volume is misbound. The judge sends his clerk back to the chambers, and sure enough, Amsterdam is correct that the judge's volume is misbound. Amsterdam is, I think, a complicated figure in this history. But the first transformation that happens is he gets the NAACP into the business wholesale of fighting the death penalty. And there's no single moment where this happens, but between the end of 1964 and the end of 1965, the NAACP, as a practical matter, is representing everybody on death row regardless of race. And there's one scholar at the University of North Carolina who thinks the NAACP's expansion of its mission beyond blacks has some problems for it, has some problematic consequences both internally, institutionally, and within this debate. But they do it. They get into it. This becomes known. They don't say, today we're going to undertake the moratorium strategy, but there is a point in this history where it's clear they're trying to create a moratorium. And Amsterdam's calculation is that if they can stop all of the executions in the United States, they'll put a collective pressure on the Supreme Court to force it to decide the constitutional issues, and will put the threat of blood on people's hands, on the justices' hands, so that it'll maximize the pressure on them to find the death penalty unconstitutional. Again, I think this is fair to say, regardless of your view on the death penalty, the NAACP Legal Defense Fund, in an era without internet communication, faxes, stops executions in the United States for 9.5 years. And there is no legal feat that I'm aware of that is comparable to this. It's extraordinary. Maybe a disaster if you like the death penalty, but even still you could say, man, how did they do this? So they do succeed. Their tactic puts pressure on the Supreme Court, and I know from talking to the clerks for the justices that the justices did feel a great weight from the moratorium. And I'm going to try not to overwhelm you with a lot of case names. I think there are about 4 that you need to know to understand this history. In 1968, the Supreme Court hears a first set of challenges, which is to the way juries are instructed in capital cases. And Potter Stewart, we'll get back to him in a second, a moderate Eisenhower appointee, former Cincinnati politician, writes an opinion that makes the jury selection procedures more friendly for opponents of the death penalty. And he believes, and you're going to hear this story again, that he's ending the death penalty in the United States, that it will make it so difficult for prosecutors to select a death-qualified jury that they're just going to stop doing it. So this decision is Witherspoon versus Illinois. P.S. The death penalty doesn't end. Then following term, there are 2 cases which could have taken this history in a radically different direction. There's a case called Maxwell versus Alabama and Boykin versus Arkansas. Maxwell versus Arkansas and Boykin versus Alabama. Not that any of you would have cared that I got that wrong, sorry. Where the court took up, under the Due Process Clause, whether the 14th Amendment required states to have standards in death penalty cases. Heretofore, juries had simply been asked whether the defendant should die. And also whether or not the death penalty for robbery was disproportionate and hence unconstitutional. This was Warren's carryover term. Nixon had been elected, but Nixon asked Warren to stay on for 1 additional term. And Warren actually, though you might think he played his cards pretty close to the vest in sort of a lame duck status, he actually seemed very liberated by the status, and he was game to strike the death penalty down on 1 or both of these grounds. So without going through the whole dramatis personae, there was ample support to strike the death penalty for robbery down, and not ample support, mixed support on the question of standards. And just for any of you who've thought about law, telling the jury the standards by which they decide a case is a very difficult proposition because it's very, very hard to codify how people exercise their judgment. And the question is whether you can specify a degree of certainty to guide someone's decision-making. Pardon me. And there's a justice named John Harlan who was a lawyer's lawyer, and he took that question very, very seriously. For some reason, and I don't have any insight into this one, I can only make educated guesses about a couple of these things. Warren assigned the case to William O. Douglas. Sorry to say, Douglas was honored recently by John Jay. Douglas, though a liberal champion, is one of the worst people I've ever read about in my life. He was a serial cheater on his wives. He was abusive to them. He was grossly abusive to his law clerks. I met one of his former law clerks recently who's at University of Texas Law School, and he said he used to bolt asleep at night having a nightmare about Douglas. He would press this buzzer and signal the people into his chambers. He routinely, once a term, there was a tradition, he wouldn't speak to one of the clerks. He would freeze them out. And he had no allies on the court. He was an iconoclast. He actually had multiple chances to run for the vice presidency of the United States, turned it down. He had tremendous reservations. He referred to himself as having a Hamletesque macaroni spine. He had lots of ego problems. So Warren assigns this case to Douglas. There is this critical moment where if Douglas could have coalesced a majority around this death penalty for robbery issue, this proportionality issue, I believe what would have happened is the death penalty would have been gradually struck out over time for different classes of murders. Instead, Douglas swung for the fences. He had one ally on the court, a man named Abe Fortas. He vilified Fortas publicly within the Supreme Court in a memo critiquing Fortas for not signing on to his opinion, which would have struck them down on both grounds. Brennan was behind the scenes trying to negotiate a compromise. By the time Douglas was willing to come, well, actually, Douglas only came around. Fortas resigned in scandal. He was replaced by Harry Blackmun, and many of you know Blackmun as a great liberal champion, which he became, but at the beginning of his career, Blackmun was a consummate judicial restraintist. He was known at the time as the Minnesota Twin. He was a child, or they collectively were the Minnesota Twins. He was a childhood friend of Warren Burger's, and Blackmun did not believe the Supreme Court should be involved in the death penalty. So the votes switched from 6-3 to 5-4. Harlan kind of backed off. He didn't want to cast a deciding vote. He was a little bit ambivalent, even on the robbery issue. And so they pushed the case over, and the majority evaporated. 1971, the issues return, and the court takes them up in a case called MacArthur versus California, argued very capably by a gentleman I interviewed several times who later became the Chief Justice of the California Supreme Court, named Ronald George. And these cases are one irony. I don't know how closely you're paying attention to this, but every argument that I've talked about so far, the standards bifurcation issue, are really procedural arguments. And this 14th Amendment case was a procedural case, and they lost. It was a 6-3 decision. The justices believed that was the end of the issue. In the summer of 1971, they were about to leave for vacation. They talked about whether or not they needed to grant cert in an Eighth Amendment case. They all understood that the Eighth Amendment argument would be denied. This will shock people. Thurgood Marshall said he would not vote for the Eighth Amendment argument, okay, because the Constitution referenced the death penalty, and Douglas said he would not vote for the Eighth Amendment argument. Brennan believed, he left for his summer vacation in Nantucket, thinking that he was going to write a dissent in an 8-1 decision. Another irony of history, there's so many little paths, the historians, maybe this will resonate with them, but I'm so skeptical of any grand theory that attempts to explain anything like this. Hugo Black, who was a literalist, wanted the court to take the Eighth Amendment case to consolidate his gains. He wanted a decision establishing for posterity that the death penalty was cruel and unusual punishment. He pushed the court to take the case. They identified a couple of cases over the summer. Everybody understood they were cleaning this up. New term begins, and the whole thing unravels. Black becomes sick, resigns from the court. Harlan becomes sick at or around the same time, resigns from the court. So you have two new justices appointed, Powell and Rehnquist. Term opens, they conference the cases. Lo and behold, there are 4 or 5 votes to rule the death penalty unconstitutional. in the long version of this, I'd say why I think Marshall changed his mind. One argument is he never really meant it. He never really would have had the heart to vote for the death penalty. Another argument, and these aren't mutually exclusive, is Marshall was quite sick that summer, and I think there's some reason he would have had some mortality salience at that point, and that might have got him thinking more about his legacy. Can't possibly venture a guess Douglas is a wild card, but I also just don't think that Douglas possibly could have cast a vote against the death penalty. But here's the surprise. So 3 people say it's unconstitutional. Potter Stewart says he's going to vote for it to be unconstitutional. And he says, and he tells his clerks, he's going to issue, my best friend loves this, it's his favorite phrase from the book, a short snapper. And he's going to say that the death penalty is cruel and unusual because it treats people as a means to an end. To my knowledge, I had never read that before. I'm not aware of anybody having reported that. So there are 4 votes now to strike down the death penalty. It comes down to, there are 4 Nixon appointees on the other side. It comes down to Byron White. If you've never read about Byron White, you should. He's one of the strangest men I've ever encountered in my, not personally, but from afar. White was a Rhodes Scholar. He took off during his first semester at Oxford to play football in the National Football League. He was an All-American at University of Colorado, and his spare time from his Rhodes, he led the NFL in rushing. He went back to finish his Rhodes, came back to Yale Law School, took off 2 more semesters to play in the NFL. I mean, he's an all-time great, Whizzer White. But he's a bizarre man. He was intensely competitive. There is a basketball court at the Supreme Court known as the highest court in the land, and White relished laying elbows into his fellow clerks, and he to the clerks. I don't think the other justices were playing, though that would be a great image. But White was consciously defiant of labels, and in his psychohistory you could maybe explain some reasons why this was so. He also went to Yale at a time where legal realism was really coming into focus. And White seemed to purposefully act in a way so that nobody would be able to pigeonhole him. Anyway, at this first conference, White says he's going to vote against the death penalty. So all of a sudden, confetti, there's a 5-4 majority to rule the death penalty unconstitutional. Sometime over the next week, White changes his mind. He withdraws his vote. And there's now 4-4 with 1 on the fence. Throughout that term, the justices proceed not knowing which way the case is going to come out. And there is a surreal moment. Harry Blackmun has written an opinion, an agonized, hand-wringing opinion. If I were a legislator, I would vote against the death penalty, but I'm constrained by my role. I can't do this. Blackmun doesn't know whether this will be a concurring opinion or a dissenting opinion. The justices meet in their conference room, and of course, this would be a simple matter. They're discussing whether or not the vote is 5-4 one way or 5-4 the other way. They speculate, how did White vote? Of course, White could simply say, it doesn't matter how he voted, how he's going to vote. He doesn't say a word. So they spend the whole meeting just speculating about his vote. And the case proceeds until early June of 1972 with no majority. Potter Stewart, on June the 7th, 1972, tells his clerks he's going to go to Byron White's office to talk about the case. We know what Stewart's position was on the death penalty around 11 o'clock that morning. We know what it was when he came back around 1 o'clock that afternoon. I think it's pretty fair to extrapolate what they agreed to. White said to Stewart that I won't vote for the death penalty if you rule against it on moral grounds, but I'm willing to write an opinion, go along with an opinion that strikes it down on procedural grounds. And some Candace and others who have taught this stuff, you know that the most famous line from the death penalty cases is from Stewart's concurrence that the death penalty is cruel and unusual in the same way as being struck by lightning. That language had never appeared before. Stewart, if you go to my website, you can see the legal pad where he wrote it for the first time on the weekend following his meeting with White. And that principle, that bedrock principle that the problem isn't the death penalty, the problem is the death penalty's application, became law another 2 weeks later. White's opinion, by the way, said the problem with the death penalty was that it was used too infrequently to deter. In other words, we need to use it more. Furman, there's never been a decision like Furman in the history of the United States. It was, I have some, it's like 60,000 words, longer than The Red Badge of Courage and some other moderate length novels. It had 9 separate opinions, and this is critical to the history. No 2 justices in the majority agreed with the other's opinion. So there was no plurality opinion. There was no consensus. There was nothing, okay? They could, and this history turns out differently if they could have agreed to a view. Interestingly, one opinion mentions race. It's William Douglas's. Thurgood Marshall's does not. Interesting to talk about why he left it out. I have my views, but they're speculative. The decision issues, and let's say this. Everybody on the Supreme Court believed that was the end of the death penalty in the United States. Berger says he's disappointed at how the cases have come out, but at least they won't come back to us anymore. And everybody clearly believes that, and they're not dissatisfied with that result. Stewart, if you want to talk about how he made his Faustian bargain, I don't think he thought it was a Faustian bargain. I think Stewart honestly believed that he had his finger on the pulse of the American people. The death penalty just needed a nudge in the right direction and it would end. And query how a white man who spent his life around other white men and played golf at Chevy Chase Country Club in a suburb of Washington, D.C. possibly could have failed to be in touch with the American people. But somehow or another he was. Stewart was spectacularly, colossally wrong. The backlash against Furman began instantly. I believe, this is debatable, but I don't see this as seriously debatable. That backlash had as much to do with a reaction to the Supreme Court as it did as an expression of support for the death penalty. Remember the context of these cases in the early 1970s. Talk about this, Vallee always has to remind me of the metric that I cite in the book, but the index of desegregation, right? Dissimilarity. So here's a statistic. I'll remember the statistic. I won't remember the title. In 1968, the percentage of schools in Alabama that were minimally integrated, meaning they had at least one white kid and one black kid, was less than 1%. So Brown versus Board of Education was nothing. What changed it was busing, and the busing decisions begin in 1971, and see Common Ground or whatever, if you lived through it, people didn't like the busing. Roe v. Wade, people didn't like Roe v. Wade either. But the thing is with Roe v. Wade and the civil rights decisions is that they were by and large consensus decisions by the Supreme Court and not challengeable on their rationales. Not so with Furman v. Georgia. Furman v. Georgia had no consistent rationale, and the states understood that it was a vulnerable decision. White had almost explicitly signaled that his vote was changeable. All of the conservative Nixon justices had said their votes were secure, and Potter Stewart, they couldn't have known what was in Potter Stewart's head, but we know Potter Stewart was, well, we'll get to that in a second. Anyway, over the next 4 years, 37 states passed new death penalty laws. They go in 2 directions. Some states make the death penalty mandatory, the reasoning being if we just execute all murderers, no arbitrariness problem, we treat everybody the same, nice solution. Path number 2 is that states adopt some type of guided discretion. Most of these ironically follow the model penal code, which sets out a system of aggravating factors. So like you kill a police officer, that makes you death eligible. They bifurcate trials into a guilt phase and a sentencing phase, and they create some mechanism for appellate review. Irony, number 1, the author of the model penal code, Herbert Wexler, was himself an opponent of the death penalty. Wexler included the death penalty in the model penal code as a compromise very similar to the one that Stewart made and Warren would have advocated. He thought the model penal code was a larger project, and that if he made the death penalty an issue, that it would deflect attention and create controversy around the larger question, which he thought was to regularize criminal law. Irony number 2 is I don't think any of these things really do very much to regularize the death penalty. I just say I don't think to be polite, but they don't do anything. Bifurcated trials, if you took a death penalty class with me, I'd actually make the argument that they make defendants a little bit worse off because of when mitigating evidence is presented in their case. And aggravating factors would be a meaningful change, but the way they're implemented in the United States, and not only was this foreseeable, it was foreseen, it was done. So look, whatever your view on the death penalty, there's a big difference between a death penalty that's reserved. Everybody always wants to, I'm sure you all get the question, would you support the death penalty for Hitler? Look, I'd feel differently about the death penalty reserved for Hitler than I feel about a death penalty reserved for poor black people who kill whites in the South, right? I probably don't like either, but I'm willing to spend a lot of energy challenging number two, and I'm not going to lose any sleep about number one. So if states had reserved their aggravating factors had reserved a short list of aggravating factors like genocidal maniac, then I don't think you have much controversy. But in fact, the lists are police officers, and once you included the police officers, the corrections officers wanted in too, and the firefighters. And if you're going to protect the elderly, well, why don't you protect the very young? And even when Georgia statute was initially passed, it included a catch-all aggravating factor, which was whether the murder was heinous, atrocious, and cruel, as if you can come up with the murder that's not heinous, atrocious, and cruel, right? You might be excluding euthanasia and including everything else. So aggravating factors are vastly overbroad. And this didn't matter. What does matter to this history is the model penal code had an imprimatur of credibility. People saw it as regularizing the process, whether it did or not. So these issues have to come back to the Supreme Court. They have to decide what to do with all of these new statutes. And here there's a dynamic, a little bit of a personal dynamic to it, which influences the outcome. Berger and the other Nixon appointees would have just allowed the mandatory statutes, the whole kit and caboodle. This is really interesting. I don't know if any of you have ever read The Brethren, but in The Brethren, there's, Candace is nodding her head, palpable loathing for Berger. And I can now verify that they loathed Berger. I mean, even his allies, they thought he was a buffoon. I mean, the clerks that I interviewed, and it was an amazing experience. These interviews were often very cathartic. People were telling me stuff that they had mixed feelings about. But they couldn't wait to tell me about what an idiot Berger was. And Powell clearly perceives a moment to create a middle ground on the court. And Marshall and Douglas's votes are secure. Marshall and Brennan's votes are secure. Actually, Douglas has gotten very ill and has retired by this time. He's replaced by John Paul Stevens, who you also know later as a liberal, although question whether he deserves all the credit he gets on that count. But Powell, Stewart, and Stevens get together and they have lunch at a restaurant called The Monocle. You can go there. You can have the same thing Lewis Powell had. It was a hamburger, medium rare. Don't ask me why I know that, but I know it. And they decided that they were going to split the baby. And they were going to rule the mandatory death penalty statutes unconstitutional and uphold the guided discretion statutes. Now, there's a huge problem in this history. It's really glaring to if you've litigated in this universe, if you've thought about it. There's so much devil in the details of what the requirements of guided discretion are. And I mean, I could say a lot of things with confidence to you. There is no, I read everything and talked to everybody there. There's no evidence that they sat down and said, wait a minute, is this list of aggravating factors too long? Or, and Candace will know this and Valerie will know this, the Texas statute was basically a mandatory death penalty statute disguised as a guided discretion statute. The only question they asked was whether the murder was deliberate, right? And as if it wouldn't, and whether the person posed any risk of future dangerousness, as if any human being doesn't pose some risk of future dangerousness. The Troika, as those three justices came to be known within the court, spent no time thinking about whether Texas's statute should be grouped as a mandatory statute or an arbitrary statute. They upheld the kit and caboodle. If the state had made an effort to curtail discretion, it was upheld. And that has huge consequences. As any of you know, it doesn't make sense to talk about the death penalty in the United States. The death penalty in the United States is a Southern phenomenon, and it's largely a Texas phenomenon. And I can't help but think that this history is a little bit different if Texas had actually been put through the paces of developing some quasi-meaningful system for guided discretion. But what's really poignant about that is that deal, those three men, Stewart had already said he thought the death penalty treated people as a means to an end. So he was a principled opponent of the death penalty. but felt very constrained by what he had written in 1972, couldn't very well go and say, I didn't really mean what I said. I just said that to get Byron White's vote. In fact, I'm a moral opponent of it. He was a lawyer's lawyer, too. He was very closely allied with Harlan, and I actually think, digression, but Harlan's death is one of the things that liberated Stewart to vote as he did and act as he did in 1972. So number one is against the death penalty. Stevens in 2009 in a case called Bays v. Reese, again, they've all heard my rant on this. Stevens gets celebrated as an opponent of the death penalty. He's clearly somebody who has very, very substantial reservations about the death penalty, which he expressed in that 2009 case, which was about botched lethal executions, by the way. But he voted with the majority, which drives me crazy. I mean, he had ample opportunity to vote against the death penalty in that case. He didn't do it. But clearly against capital punishment. Powell, who, this is kind of a surprise. Powell had a little bit of a reputation. He had a mixed record on civil rights. He may have been a desegregation resistor, a modest resistor, but a resistor all the same. By the time Powell retires in 1990, he gives an interview to his former law clerk who asks him if there's any decision he regrets. He says it's the death penalty decisions. You want to beat your head against the wall. McCluskey versus Kemp, which is a seminal case, which truly would have revolutionized criminal justice in America. That much more so than the cases that I wrote about. McCluskey v. Kemp said the problem with the death penalty was the racism in its application. And Candace is nodding her head, and I'm glad. But I'm on a jag about this. Man, if you're worried about the death penalty in the United States, you should sure be worried about the prison system, because every argument that you can make against capital punishment, that it doesn't deter very much, that it's cost ineffective, that it's racist, is true to a much greater degree of people who are sentenced to finite sentences than it is to capital punishment. But somehow Powell he only came around between McCluskey when he cast the deciding vote in favor of capital punishment, clearly worried about dismantling the criminal justice system in America, which is what he would have done, and in my view, correctly. But he's experienced a change of heart by 1990, and I do think it says something, however you want to make of it, that so many of the people who live this life, that their collected wisdom at the end of their life was that death penalty didn't work, which is, I think, a very different question than it's inhumane, which it, I think, is, but it's a very, very hard enterprise for lawyers who pride themselves on process and certainty to come up with a system that meaningfully separates who should live from who should die. So I'll pause there and take the conversation wherever you would like.
So I'm going to ask audience questioners to use this microphone, even though I know some of you won't like it. But we are recording this, and the microphone picks up your voice. So do we have any questions in the audience?
I was hoping for an easier question.
This isn't a difficult question. In fact, people have read the book, or at least parts of it. The PhD students who are here read the chapter about guided discretion and the aggravating factors you mentioned. So you guys should jump up if I'm giving our ideas incorrectly. When we discussed this in class, I was making the argument, Evan, that basically over time, the aggravating factors guided discretion approach could kill the death penalty, to mix metaphors, and kill it by 1,000 cuts, if in fact the legislatures ever revisited their statutes, ever did do what Texas should have done. And of course they haven't, but arguably this was the appropriate thing for the Supreme Court to do, to turn it back to the legislatures. Now, over time, that might work. It hasn't. Was there any indication in Woodson, et cetera, all the cases subsequent to Furman, that any of the justices saw that potentially as the outcome?
That it would lead to death penalty's abolition? Nah. Yeah, I mean, it's a great wish. I mean, what resonates with me when you ask that question is I recommend if any of you have read Malcolm Gladwell's new book, David and Goliath, there's a great chapter at the end on, it's on criminal justice basically in the United States. There are a number of John Jay professors who were cited. My joke is if you can't take the time to read President Travis's report, this is a way to become quickly conversant in all of the hot button issues in criminal justice. And it begins with a very poignant story about a man in California whose kid is killed, and he becomes an advocate for three strikes laws. And of course, I mean, look, I don't know how many, as certain as we are that carbon dioxide emissions are causing global warming, we're certain that three strikes laws don't work, right? So we can't prove anything to a metaphysical certainty, but we're pretty close to certain about that. But what you see is the utter disconnect between the political process and rationality. Because you go and you say, well, I want to be protective of people, and it has a superficially sensible argument, right? Harsher treatment will lead to, right, not to you, but to most people, will lead to less crime. And it doesn't work. And in this case, the argument is so nuanced in the totality of the experience because, you know, if a state said, we want to protect police officers, so we're going to write an aggravating factor for them, you can't say that that is irrational, right? Now, what do I say to them when you expand the list to corrections officers? Well, you know, they're loosely analogous. Of course, you may lose some deterrence by doing this the more you expand the mission. And every time you add somebody else to the list, whatever possible deterrent effect there is, and if there is deterrence, it's a teensy-weensy little bit of deterrence, you're undermining it. But in each individual case, it seems rational. And so that's what strikes with me is this gross disconnect between the rhetoric and the data, yeah?
What about felony murder? I mean, I'm sorry. Basically, I don't see this as a deterrence argument. I see it as a proportionality argument. Sure. And insofar as you can get states to argue proportionality, there is a trend towards slow abolition. We have seen East Coast states get rid of their death penalty statutes recently. And as far as the aggravating circumstances, example, felony murder. In California, which does have
that felony murder is a ridiculous aggravating factor.
Yes.
Oh, yeah.
I mean, you could convince...
But there are lots of examples of those. It's a good one.
This is my point, is that there are ways to nibble away through the state legislative process. I think maybe the legislature of California would be willing to revisit their statute. That would empty their death row almost, as an example.
Sure. Well, this is all speculative. I think, I don't know what
gang enhancement, Valerie says.
What's that?
Valerie says it's actually the gang enhancement in California that kills you.
I think the death penalty is going to end. It's very, very, I am a gambler. I'd put a lot of money on the proposition that there won't be a death penalty in the United States at some date. Question is what that date is and how it happens. So you've already, I mean, you see diminishing support for capital punishment. I believe I'm a great optimist. I say this to my students all the time, and it's part of why I like being a teacher, part of why I'm proud to be from a family of teachers. That's ridiculous that makes me sad. Is I think young people are much more tolerant than our generation, as our generation was more tolerant than the people before us. I don't know that there's a, I don't like to think that the arrow of change is inevitable always, but I think there's a lot of empirical evidence to suggest that in a matter of time, the death penalty in the United States will end. Now, it ain't going to end in Texas without a fight. And so the question is, when there are these holdout states, what happens? Right. And I think what will happen is, after 35 states have either don't have the death penalty or have repudiated it, that the Supreme Court at some point will step in, as it did with outliers. God, you won't believe this, but there's a Supreme Court case on the proposition of whether you can execute somebody who is insane. I always have to spend half a class when I teach this explaining how this could even be a possibility. And there was one state in the United States at the time who would have executed somebody on these facts. So the court, steps in and cleans this up. I don't think... It was Florida. I don't think that, I don't see a reason to take a shot at Florida for that one, though. It's very hard to see the Supreme Court leading public opinion again, though. And I think even in Perry and the gay marriage cases, you've seen them exercise restraint that I think is very directly informed by the experience with capital punishment. And actually, though I think, not that you care, I think gay marriage is infinitely clearer cut issue than the death penalty. I could imagine cogent moral arguments in favor of the death penalty. I cannot, sorry if you have this view, I cannot imagine a cogent argument against gay marriage. And I was still not so unhappy that the Supreme Court held back a little bit because I was worried that it would have engendered that same backlash that happened in '72.
Hi. Let me take the story forward a bit and then go to the outlier question that you raised. Going forward from Gregg, the court has cut back on the death penalty in numerous instances having to do with rape of an adult woman, rape of a child, the mentally retarded, juveniles of various stripes, and so on. So it has been raising the threshold. But the textualist question that hangs over all of this is whether, and I have no answer to this, I'm curious, you've done a lot more research than I, the textualist question is whether the court could make some kind of absolute determination that the death penalty under any and all circumstances is cruel and unusual punishment consistent with the various references in the text to the permissibility of capital punishment. That's not a problem with respect to, say, gay marriage, where equal protection could offer the court a way to do this. But the text appears to presuppose the legitimacy of the death penalty. So are you aware of any way that the court can do this not by death by 1,000 cuts, but instead by one clean move?
Sure. I mean, the court's existing under the court's death penalty jurisprudence. Almost all of the cases that you just mentioned have been, the death penalty has been struck down on the basis of a trend against the use. So, I mean, the execution of the mentally retarded, Scalia was apoplectic on this, and I actually think he has the better of the argument as a legal doctrine matter. He says, well, how can you say there's a consensus against executing the mentally retarded when a majority of states would do it? And the majority relies upon the direction of change in states. So they have a doctrinal way that they could do it. I just don't think the issue is going to be teed up for them anytime soon. I'm asked this, I get asked this question every interview I do. So would the Supreme Court strike the death penalty down? I believe the vote would be, my guess is, it all comes down to Kennedy, right? It's all speculation about which way Kennedy would go. My hunch is he'd actually vote against the death penalty. My stronger hunch is he won't vote to grant cert, and it's all because they're aware of this history. So I don't think this cast of characters is going to, whatever, that argument could be written. I just don't think you're going to see that any time in the next 10 to 20 years. But, I mean, I'm just making guesses now.
Hi.
This is a man who stands for fairness.
Your argument seems to hinge on the idea of the death penalty as a deterrent. And my first question is this part of the court's reasoning that the death penalty is a deterrent? Because the other side is, no, it doesn't work as a deterrent, but is not the death penalty targeting an individual who committed an individual act and its punishment for that individual act, as opposed to seeing this as a larger societal issue of we have to do this so that other people won't. Instead, it's this person did this and we are going to punish this person.
Just help me with one thing. When you said my argument, what do you take my argument to be?
No, I just heard toward the end of your talk
I did say the word deterrence.
Yeah, the word deterrence, yeah.
I try not to, when I talk about this stuff, I try not to impose my view on the death penalty into the conversation. I mean, I have a view. I'll give it to you if you want, but I don't think my view, and my students know this, except I'll talk a lot, but I don't think my view is any more legitimate than anybody else's. The deterrence, I'll say this, I have a 7-page single-space footnote in the book about the deterrence evidence. I think abolitionists oversell the deterrence case. It is conventionally portrayed as there is no evidence that the death penalty deters. I think it is fairly stated as there is mixed evidence whether the death penalty deters. Most of the positive evidence coming from economists, most of the negative evidence coming from criminologists, questions about whether it's methodological differences that lead to their different conclusions or ideological differences that lead to their conclusion. To me, I have a quote in the book from Franklin Zimmering, who's a renowned criminologist, and he was there for when this debate began, and he said, "But I don't give a shit whether the death penalty deters." And that's more or less how I feel. I mean, I'll say this. If it deterred a lot, that would affect my thinking, just as if it really did produce a great sense of closure would affect my thinking. But I'm just honest about my predispositions. I have a vague, I'm not religious at all, so it's ironic that I'll say this, I have a vague spiritual belief that you should only kill people as a last resort, and so I approach all public policy questions from that standpoint. In terms of whether it's influential to the Supreme Court or not, I just got to say this. There's text and there's subtext, okay? There is some text about deterrence. There ain't nobody in this universe whose mind, in the legal universe, whose mind is being made up by that question. And my general feeling about this is there are no open minds in this universe. I mean, there might be, this is a fight for teaching our students and our kids values. That's what it's about. It's about forming their predispositions so that when they interpret ambiguous evidence, they resolve the doubt, which exists in all social science questions, in favor of the tolerant side and the less punitive side.
We've got time for 2 or 3 more questions, I'd say.
I'm kind of interested in you're talking about how the justices went to the Monocle for a lunch, and when you talk about how they interacted in these cases, it's almost like they were acting as legislators as opposed to judges. And what from the clerk's perspective, how did the clerks react to this, given that you interviewed them?
It opens. So Jim's a political scientist, and it opens a whole interesting set of issues to me. So when I thought of this, I had a book in my head that was very influential to me as an undergraduate. The chance that you've read it is very slim. Have you ever read Deciding to Decide? I had a professor named, you've read it? So H.W. Perry was my professor, and Deciding to Decide is about how the Supreme Court selects cases to grant certiorari. And I think H.W.'s project had a larger project. Project number one, one thing is he has a chart in his book describing how the Supreme Court decides it. So if it's this type of case here, and the chart has like 23 different boxes and 7 different paths, it's incredibly messy. But at a larger level, I think I take him to be a qualitative or critical researcher, that he was much more about talking to people as opposed to quantitative analysis of outcomes. And my wife is we've decided in the family she's a critical researcher, but I take that part of the project very seriously. And I'm very, very skeptical of the idea that any grand theory could explain human behavior in context, or that grand theory would have to be so nuanced to account for so many contingencies that it just wouldn't be interesting to study as a theory. So what you see in this history is that the justices operated differently at different times. And one of the kind of linchpins, the deciding points in H.W.'s flowchart is whether the justices care or not about a case. And so there's a whole host of cases, let's say tax cases. They're not interested, right? They'll do it because it's part of their job. And they operate, he calls it jurisprudentially, meaning they'll do their best job to try to apply the law as best they understand it, which is probably not very well. And then there are some cases where they operate politically, and meaning, or attitudinally, right? So they have an agenda, they have a predisposition. What's interesting about this, what I think, is that bit with Stewart negotiating with White, I actually don't think you see a lot of in this, what I read about the Supreme Court. So I think it's a very, very unusual event that they actually engaged in horse trading. Actually, in H.W.'s book, he says it might be better if they engaged in some more horse trading. Like, horse trading isn't inherently bad. In terms of how the clerks reacted to it, they knew. I mean, the way I reach my 99.99% certainty about what happened in that office is Potter Stewart's clerks, who were Ben Heinemann, who's the general counsel of GAE, and William Jeffress, a top litigator in Washington, they were very upset. And, they understood what had happened and why he did it, but they didn't like it. These cases were different. The clerks talked about them at lunch all the time. Depends on, in terms of how much they talked about it with the justice, depends which one it was. Stewart was a very nice guy, apparently, talked to his clerks a lot. Douglas, no interaction whatsoever.
So if no one else has a question, I have one, but I want to give somebody else a chance. No more questions from the audience? So, Evan, my question is, sorry, I'm standing up. Given the current media narrative around botched executions, the cocktails of drugs that are, causing some painful executions and some poorly managed executions, do you see that? What's the likelihood in your mind of that leading to some litigation? And if so, what outcomes do you think might be possible with that sort of litigation at this point?
Well, guessing again, it'll certainly lead to litigation. If you're a death penalty litigator, you raise every argument that you can raise on your client's behalf. So I'm raising, everybody's going to raise this argument. What outcomes does it lead to? At the Supreme Court level, this 2009 decision, Bays v. Reese, is on point. I was saying, he's gone. I was saying to Larry earlier, I was actually a little bit surprised by how much attention the Lockett case got, because jurisprudentially, it's kind of like old news. I mean, this is exactly what the Supreme Court. Well, I guess it's different. In Bays v. Reese, it was the risk of a botched execution. Now we have the botched execution, but there are lots of botched executions, including electric chair electrocutions that go wrong. I don't think this is going to change the Supreme Court's mind. I do think, though, there is a corollary issue to this, which is the secrecy that surrounds the execution protocol, which is litigatable. And I'd have to think, I've been thinking about it, I have to think about it more how it would be teed up, but I don't think the states will be able to get away with indefinitely failing to disclose what the protocols are. And that you understand that's part of the problem here, right, is that they're not actually willing to say which drug they're using as a substitute and what the dosage is. And so that feels to me like that change. But I'll say this other thing. Like I said earlier, there are no open minds. People seize onto whatever, they grab whatever they can to try to persuade people. So, if you're against the death penalty and you see this happening, it's obviously an outrageous event, and you start talking about it, because you think, you might be able to persuade people. Actually, in my litany of reasons to be against the death penalty, it's either at the bottom or not on the list at all, because, I hate to be macabre, but I do many of these exercises when I teach a death penalty class. If you think about the average suffering that somebody endures when they die, most people suffer. And, lethal injection might be humane if you have a very painful cancer or something like this. And so I actually wrote a law review article, and I kind of laid out the spectrum of suffering, right? And I think it's probably less than average suffering. Now, if you're the unlucky one and your execution is botched, that's probably more than average suffering. But, Dr. Kevorkian was there to satisfy a demand. To me, there's so many better reasons to be against it. But, however we get there is also fine with me. David?
Any last questions?
Hello, and thank you, of course, for a fantastic talk on, a great topic. Being a foreigner in these, strange and unusual lands, the death penalty is, of course, one of those subjects that no one at home I come from Australia. No one at home understands how
Right.
it can still be an issue. Exactly like guns, of course, exactly like many of the other things, and prison populations. So I suppose my question is just very speculative, which is on the lands. To what extent does the debate over death school shootings and prison populations and traffic accidents that are insane, numbers of which that are insane, the levels at which the United States as a nation is able to put up with industries of death, just would never happen, and the whole gun shooting thing. Is there a larger social history of death that this might be one story of, that might form the basis of your next book, for instance?
I lived in Australia for a while. I love Australia. I actually worked for a barrister judge there. He was a judge. And he couldn't understand it either. He would say these things all the time. If you're genuinely interested in this issue, there's a book by a sociologist at NYU named David Garland. It's pretty good. I don't know if it breaks a lot of new ground, but it's a very interesting synthesis. It's this perspective of, from the standpoint of a European, how can I make sense of the fact that the United States has the death penalty? And it's interesting. Look, I'll say this in a host of ways. I have a lot of different bits of evidence that get me to the same conclusion. It doesn't make sense to think of the United States as one nation. The United States is two nations, vastly polarized nations that maybe share some common values, but I'm not even sure. I'm not sure when I read a Supreme Court decision upholding public prayer that I can reconcile that with my understanding of what it means to be an American. But let's say this: there probably is a common limit to how much intrusion into freedom of religion or freedom of speech we would tolerate. So that's probably the core American value. Then on these issues of punitiveness on gun rights, there's no way to recognize the ethos of red states and blue states. They're just different. And what you see in the Supreme Court, and you even see in politicians who try to get elected, right, is somehow a desire to moderate that conversation, if you can call it that, or that intense conflict between this liberal tolerance state and this conservative theological state, right? And the death penalty is at the heart of it, right? I mean, we just wouldn't be here. California of those states is the most punitive. They have 660 people on death row. They've executed one person in the past 30 years. They're the punitive end of that spectrum, right? New York had the death penalty post-Gregg, never executed anybody. So you just wouldn't be having that conversation. And the question is, I think this question goes back to the Civil War and Reconstruction. How much are you willing to impose on Texas? How much are you willing to impose on Alabama? How much can the relationship tolerate? Very, very troubling question. But look, I always feel it's important to say this. Many of these issues are very morally complicated. I have to say, guns don't resonate with me. I don't understand that one. But capital punishment, I see both sides. I even see both sides on abortion. They're very difficult conversations. But that's what I think is the story. It doesn't make sense to talk about the United States as a monolithic entity. So, yeah.
You want to take one more, Evan?
Sure. I'm indefatigable.
Thank you. It's good to be indefatigable. As a historian, I'm wondering what triggered your interest in this particular area of the law.
Death penalty? Well, I worked on a case in Alabama. My answer is going to be so unsatisfying. I didn't like being a lawyer. The only experiences that I liked were the pro bono experiences. I got to work on a death penalty case in Alabama. I was so happy they let me do something that I actually cared about, that I immersed myself in that. I felt like I was Robin Hooding, that I was stealing money from this wealth. So what if I was giving it to some poor murderer? At least he was poor. I am very fascinated by it. I mean, I think at heart, interestingly, I have a yin and yang, my mom and my dad. My mom is a creative sort, and I think, I don't know whether that's the yin or yang in that, I definitely am at heart a writer and a creative person. I'm very interested. I mean, if you read my book, I think it's very novelistic. I'm interested in the characters of that, and I think the human drama of capital cases is very compelling. So, you know, it appeals to me. And but you know, I always wanted to do something that I thought made a difference. So that's why I became interested in the death penalty, as opposed to tax law. Not to disparage people who do tax law. So.
All right. It's
Thank
about
you.
time for us to wrap it up.
Thank
If we can thank Evan for coming.